Hello, I'm Kamal Basra, and welcome to Sophia Wealth Academy, the virtual editions. My business partner, Tracy Themes, and I are always looking for topics that are pertinent and important to women, and tonight is no exception. Our talk tonight is on transitioning through divorce, and we have an eminent expert in that field who will be sharing her knowledge with you. But before we get started, I just wanted to invite you to use the chat button that's located at the bottom of your screen. And if you hit all panelists and attendees, we'd love it to see where you're calling in from and if you could introduce yourself with your first name. Also, at the end of the speakers' comments, we are going to have time for a question and answer period. And in order to do that, to submit your questions, please use the Q&A button located at the bottom of your screen. And also, a question we often get is, will you be able to access this webinar after it's over? And we will be sending a link. We are recording it today, and we'll be sending a link to your email address over the next couple of days. So with all of that, let's get started. And I am pleased to introduce to you Karen Redmond. Karen was called to the bar in 2004 and has practiced exclusively in the area of family law since 2008. She opened her own law firm in 2011 and has also been teaching in the law faculty at UBC as an adjunct professor since 2014. Karen is a mediator and a member of the Collaborative Divorce Vancouver Group, having served on the board for 6 years, finishing as board chair in 2017. Karen's proudest accomplishment is her 3 daughters, who are all currently pursuing post-secondary education, which may require Karen to remain in the practice of law indefinitely. And with that, welcome, Karen.
Kamal, thank you for that lovely introduction. I don't think I've ever been called eminent, but I appreciate that. It's very, very kind. And so before we start, welcome everybody. And I would love to know a little bit about the people who are attending. So my colleague is going to pop up a poll, and you'll see there the question that's up on the poll. And if you would just take a second to answer the following question about the stage of separation that you're in. So are you thinking about separation? Have you communicated your separation, the need to separate to your spouse? Or are you at the stage where you've hired a lawyer? Are you in the midst of court proceedings? Or have you finished separation, but there are complications that have come up that you need to work out with a lawyer? If you just take a moment to fill out the poll, it'll help me sort of guide the talk a little bit and give me a sense of who's watching. Okay, great. Thank you, everybody. So it looks like about 2/3 of you are at the stage where you are thinking about separation, and then we've got about 15% that have communicated the need, and then the rest of you have either hired a lawyer, are in the midst, or have finished separation, but there are complications. So it's interesting because this is actually a little bit about what my practice looks like. When people come and see me, they are often just in the very beginning stages of thinking about separation. So what I would say to you is that you're doing the right thing, which is getting information. And for the rest of you, getting information as you go forward in the process is the perfect thing to do. So without further ado, I'm going to move on with the presentation and tell you a little bit about me. So I have 3 daughters, as Kamal said, and I went to law school. I was a teacher before I was a lawyer. And when I went through my own unfortunate divorce process, I decided that there had to be a better way to do things. And I went to law school when my daughters were 1 and 4 and 5. And I tell people this all the time, when you're down and out and you've got having difficulty with finances, going back to school is a brilliant thing to do because you've got a light at the end of your tunnel, and that's what it was for me. So my daughters now are 27, 26, and 21, and as Kamal said, they're all pursuing post-secondary education. So I have practiced family law exclusively since 2011, and I can say with absolutely that I love my job. I love my job every day. Because it brings people to me when they're usually going through one of the most difficult things that they've ever gone through in their life. Tonight's presentation is about the processes that you can choose when you are going through a separation. I'm going to tell you a little bit about the substantive law, the biggest issues in family law, and then I'm going to describe to you the processes that are available to you when you're going through a separation. And I'm going to do this in the format of answering the questions that I get most commonly asked. At the end of the presentation, my hope for you is that you have sort of a sense of maybe what to do or what not to do. And I'll remind you about this at the end of the presentation, but if you do have questions that I haven't answered, you will have a chance to ask them. And then I'll always recommend to you that you just pick up the phone and call a family law lawyer. So the place that we're going to start is I'm going to tell you the statutes and the resources that we rely on when we are engaging in a family law case. The Divorce Act is the federal statute. Now, this applies to you if you're married, obviously. And the Divorce Act, I'm not going to tell you about the Divorce Act right now, but I'm telling you that the Divorce Act is the statute that we use to facilitate divorces. And it's the statute that we rely on when we're looking at things like custody and guardianship and child support and spousal support. If you would like, you can read the Divorce Act, but a better way to do this is to go to a lawyer's website, and most lawyers' websites have resources and links. So those links would connect you to the Divorce Act. I don't suggest you read the Divorce Act, but you would be able to find articles about the Divorce Act. The Family Law Act is the British Columbia provincial statute that governs property division, spousal support, and child support, and is the statute that we refer to also for married couples. But when couples are not married, we don't look at the Divorce Act, we look at the Family Law Act. The Federal Child Support Guidelines governs child support, and it is a federal statute, meaning that it applies to all provinces. And this is where we look when we are inquiring about how much child support people should pay, how long should they pay, how we determine income for parties who are paying child support, and so on and so forth. The final resource that I've listed here are the Spousal Support Advisory Guidelines. Now, they're not statutes. That's why I said statutes and resources. These are advisory guidelines, but they are still a document, a set of guidelines that courts rely upon when making decisions about spousal support. And when I say that, I mean about how much income a person earns, is a person entitled to spousal support, how long should they pay, what are the factors that are looked at in determining spousal support, in determining duration, review, cancellation, and so on and so forth. Okay. The most important decision, one of the most important decisions you're going to make when you are considering separation is how you're going to do it. Because in the very beginning, you and your spouse have an opportunity to choose a process that will keep you out of court, that will have a higher likelihood of resulting in a process that's less expensive and causes less acrimony. So I'm going to describe to you 4 processes, and I'm going to start with the one that I think is the most effective in resolving family law disputes. So collaborative divorce. You may have heard of this. About 5 or 10 years ago, this wasn't as common in Vancouver, but now when the Family Law Act named dispute resolution as a mechanism that parties had to try, more people started looking at collaborative divorce as an option. Collaborative divorce is an out-of-court process. It's a process where 2 people choose 2 lawyers, and they, as a team of 4, work together to resolve the family law matters without any court intervention. The parties and the lawyers sign a contract. It's called the Collaborative Participation Agreement, whereby they are agreeing to resolve matters in a transparent way. They're going to participate with integrity. It maintains the confidentiality of the process, and it provides for support for parties in a way that the other processes don't. For example, in a collaborative divorce file, one of the very first things that we would say to a husband and a wife or partners, we would say, have you engaged counselors? Are your children in counseling? Because what's most important for us is, are the parties to a separation being supported emotionally? It is very difficult to make a decision about RSPs or houses or cars when you are in a heightened emotional state, when you're angry, or when there's things that need to be said that aren't being said and you can't communicate. So in the collaborative divorce approach, we engage other professionals who are not lawyers, who are less expensive, and who are more qualified to deal with the issues that come up in a separation that are not legal issues. Family law is not rocket science, and I say this every day, but it is challenging because the emotional issues that weave into any separation sometimes block decision making. And so when we're engaging in a collaborative process, we look at those head on, and we say, in order to make decisions, we think that it would be good for, to have the kids working with a child specialist, to have you two working with divorce coaches. We engage a financial neutral. For example, if there are assets that need to be valued, we will engage a financial neutral, with the goal being to keep the costs down and to work together to resolve the issues that most people have. They're the same issues in almost every single case, and I'm going to take you through those later. And the way we do this in collaborative divorce takes those issues and brings them to professionals who, as I said, are oftentimes they're usually more qualified and less expensive than family law lawyers. In a collaborative case, you are taking control of your case. You have the opportunity to be creative about your resolution in a way that you simply do not have in litigation. All right, so litigation, as I just mentioned, is another option. Now, when people first separate, that's usually the first thing they think of. They think, oh, I've got to go to court. I've got to get a lawyer. I've got to hire a lawyer, and I've got to go to court because I'm separating or I'm getting divorced. That's the old school way of thinking. You do not have to litigate to get a divorce. You do at some point, if you want to get a divorce, you have to apply to a court. But in order to resolve all of the things that we're going to talk about this evening, you don't need to engage in a court action. Litigation is expensive. It's destructive. It takes all of the control and the money and puts it in the hands of the lawyers. And when lawyers fight, you won't be surprised to hear that the people who make money are the lawyers. So you'll see people paying their litigation lawyers $50,000 or $100,000. I see them come in my office 3, 4, 5, 6 years after their case started, and they have absolutely no idea what's happened. They've got some court documents. They don't understand it. It was never explained to them. That's not in every case. But in many cases, litigation is a confusing process, and the hopes and the dreams and the fears and the concerns of the spouses are just disregarded. And what's focused on is who's going to win and who can present the best case to the judge. And when you put your case to a judge, you are rolling the dice. You may end up, if you commence your litigation in 2020, you've got your trial in 2022 or 2023, and you may get your case on, you may not. And then a judge may make a decision, or he may defer, may not make a decision right away. You may have to go to the Court of Appeal, and you can see how long a process like this takes, and the costs that are associated with that are prohibitive to most people. At no point in a litigation case does anybody ask you if you have your children engaged in counseling. And so for me, when I have clients come in my office, I talk to them immediately about a collaborative approach. Now, in some cases, litigation is important, is necessary, where there's extreme violence or extreme manipulation or financial abuse. I'm not saying that there aren't times when litigation is appropriate. I'm saying in the beginning of your process, it's really important to consider other options. When you do a collaborative approach, you're working with 2 lawyers and 2 people. Another option for resolution of a family law case is mediation, where you work with 1 neutral professional. You work with a family law lawyer or a mediator, and that mediator works with the 2 people as a neutral conversation facilitator. So much like collaborative divorce, it's an out-of-court process. The parties come to the table with their information, and the mediator works with them to review the outstanding issues and work through the terms of a separation agreement. At the end of the mediation, the mediator sends each party to their own legal counsel. And at that time, the separation agreement can be signed. The mediation and the collaborative divorce process are no less formal. You end up with a legally enforceable contract at the end of both of those processes, which is the same as a court order that you would get at the end of litigation. But mediation, collaborative divorce, and also the mediation arbitration process allow you to have more control over your options. The difference between mediation and what we call med-arb is that if you sign on with a med-arb process, you are giving the mediator, who is also an arbitrator, authority to make a decision for you. So for example, you attend a day of mediation, and if you don't have an agreement, then a day or two or a week later, your process turns to arbitration, and then that arbitrator will make a decision for you. So it's like a judge, but it's not a judge. It's less expensive, and again, you have more control. So that's just a quick summary of the process options that are available to you when you're separating. And I thought this comic was quite funny when I saw it. And oftentimes, it does look like that in a mediation room, but as I said to many people, I've raised 3 teenage girls. Mediation is a lot like that sometimes. So yeah, see this little cartoon here. He said, she said. This reminds me of, when you get to court with a family law case, all judges hate family law. They look at the size of the binders, and people have got their affidavits, this big, and all the text messages, he said, she said, and the judges don't like it and they don't read it. And if there's any chance for your case to get bumped, if you are a family law case, you will get bumped because nobody wants to hear it. So these are the questions that I get asked most often. And I thought this is a really good way to give information in a way that, so that I'm not speaking to you about things you're not interested in, because this is what I get asked all the time. So what is a separation? A separation is when you announce your intention to separate to your spouse. You do it in writing or you do it in person, but you are saying to your spouse, I no longer want to be in this relationship. There is no possibility of reconciliation. So today is going to be our separation date. Your spouse does not have to agree with you, okay? Your separation can be announced either by you or by your lawyer in a letter. And that's all it is. That's what a separation is. Our relationship is finished. We will not be reconciling. You announce it and then you act on it. So you move into a separate bedroom, or you move into the downstairs suite. And if there's no room for that, you notify your children's school, you tell your parents, you tell your friends, you remove your wedding ring, you stop sending anniversary cards, you stop your intimacy. So you communicate it and you act on it. That's what separation is. You do not have to move out in order to be separated. You don't have to file anything. You don't have to sign anything. That causes you to be separated. And it is important in some cases. Your date of separation is important. So it really should be recorded. It's important sometimes for division of assets. It's important for when you can apply for a divorce. But mostly you just need to have a separation date, and that's how you do it. And that's the second question was, what is your separation date? Your separation date is the date you make the announcement. And it doesn't matter whether you're married or unmarried, it's the same thing. That's your separation. So people always ask me, like, what is a legal separation? Well, you need to have a separation date. And then the document that follows from you having a separation date, the document you're going to be working towards is the separation agreement. And that's the point at which you, if you can, you sit with your spouse and you have what I call the kitchen table conversation. You make a list of all of the things that you need to talk about. The couch, the kids, the car, the RSP, the pension, the spousal support, income, tax return, and timing of everything. Because not everybody is going to be in a position to be able to sell their house 2 weeks after separation, list the house, you're paying spousal support, I'm paying child support, the kids are going here. It never happens that way. Nobody comes into my office 1 month after separation and says, I moved out, I got an apartment, these are our issues. It doesn't work that way. It's usually 6 months, we've been living together, everything's complicated, I've been using the line of credit, he's using a credit card, and there's all these complicated finances. That's the kind of thing that we're going to sort out and put into a separation agreement. That's what a separation agreement is. And how do you separate if you aren't married? you do as I said earlier, you announce your separation and then you act on it. You are going to need a separation agreement. A separation agreement is important because you need to record the agreements that you're going to make in your separation. And the separation agreement oftentimes deals with things you haven't thought of. For example, you may know, okay, look, I'm going to move out and it's fine. I'm going to take half the furniture. I've got a pension. He's got a pension. We've got a bank account and we're going to sell our house. Why do we need a separation agreement? Because you need to make sure that you've covered off all of the things that may come back a year or two later. For example, how do you know what your pension is worth? How do you know what his pension or her pension is worth? What about Canada Pension Plan credits? What about life insurance? What about support? If you don't mention it in an agreement, you leave yourself at risk for being pursued 2 years after the separation if you are common law, and up until the divorce if you are still married. So it is absolutely critical that you record the terms of your agreement in a separation agreement. And you can work that out with your spouse. You can go online and get a do-it-yourself separation agreement, but you need to take that to a lawyer before you sign anything. There's a sign in the hardware store where I live, and it says, buy the best and only cry once. And that is so true when it comes to legal agreements. This is a document that you want to be relying on for the rest of your life, and certainly in the near future after your separation. So you need to make sure that it deals with all of the things that I've just said and other issues that may not occur to you, but you certainly don't want to find out 6 years down the road that what? Why, how is that possible that you can come after my RSP that's ballooned? So it is important. And the difference between separation and divorce is that a separation is where you announce to your spouse that you want to separate, and you engage in discussions about all of the issues. And a divorce is an application to the British Columbia Supreme Court once you've resolved everything else, and the court then grants you your divorce. You don't have to get divorced. Some people never get divorced, but it's the divorce that allows you to remarry. So that's the difference. Okay, do you need a divorce? Nope, you don't need a divorce unless you want to get remarried. And how you get divorced is you ask your lawyer to do it for you. You can get divorced. There are 3 things that you need in order to get divorced. You need to be separated for 12 months. You need the original marriage certificate, and you need to have a child support agreement if you have children. So those things have to happen first, and then you can apply to BC Supreme Court to get divorced. Okay, but what does the separation agreement do? It sets out everything that needs to be resolved, and it explains what is going to happen with respect to each of those issues. You are paying child support, you aren't. When is it being reviewed? What about spousal support? So it contains every issue that needs to be resolved with your spouse and creates a final and legally binding agreement. You do not need to go to court to get a separation agreement. You can work through the terms of your entire agreement with just your spouse, and then you are going to take it to a lawyer, because I've suggested that you should do that. And that lawyer is going to put it into a formal separation agreement for you so that you and your spouse can sign it with a witness, not each other or your own lawyers, so that you've got a document that you can rely on. Yes, you do need to go to court to get a divorce, but you don't actually physically need to go to court. This can be done by way of a desk order. So it's done all electronically. Now, what if my spouse and I can't agree on anything? For example, what if my spouse, he won't even agree or she won't even agree on the process? That's something that happens almost every single day in my office. And there are options, okay? There are letters that I can write to engage your spouse in a process. If we are doing a mediation with your spouse, there are conversations that we can have. There are ways to resolve it. 98% of family law cases are resolved outside of court. So don't feel discouraged. I've mediated some very high conflict cases, and I've worked on collaborative cases where the parties have been millions of dollars apart. There are ways. Most people don't want to spend their lives paying lawyers and in high conflict litigation. And what if you can agree on some things but not everything? Well, that's great. So you record what you have agreed on, and then you go to your lawyer or to your mediator with the things that you haven't agreed on, and then your lawyer or the mediator can help you negotiate through those things. and they may raise issues that you actually hadn't considered. Okay, so this is the substantive part of the presentation where I'm going to explain to you about some of the family law issues, and I'll do it in a way that I'll try and make it so it's not too detailed or too boring. So in most cases, these are the issues that people have when they come into my office. They'll have an issue with their children. So that means they've either got a custody, a guardianship issue, or parenting responsibilities issue, or parenting time. Determination of income and calculation of child and spousal support is another major issue. And I say that because most people don't just have a T4 slip. Most people nowadays aren't employees. It's rare that I'll see a case where both spouses are employed. One spouse is self-employed, or a spouse has 3 companies and receives dividends, or there's a family trust. There are many different ways that people receive income. So determination of income is a huge issue in family law. It's litigated all the time when people aren't forthcoming with their income information, their tax returns, their financial statements. So the first step, and I'll get into this in a moment, is that we have to look at determination of income, identification and valuation of assets and debts, and then division of those assets and the mechanism for division. And you see, it's a process there, right? You've got to identify them,
your child is going to be, 8 or 10 or 12. How long do you want this to go on? And the good parenting coaches will tell you that when you're separating, what you've got to think about is 5 years from now, when somebody asks you, or someone asks your child, you're standing in the other room and someone says to your child, hey, how is your parents' divorce? You want your child to say, I don't know, it was fine, they kept me out of it. So when it comes to children, it's one of the most important parts about collaborative divorce is that it does keep everything private, and it keeps it sort of in a container and away from the harm that can be caused by litigation. So custody and guardianship are the legal rights that go along with having a child. Parenting responsibilities and parenting time are they're under the umbrella of the Family Law Act, and they are self-explanatory. The parenting responsibilities, who has the responsibility to do what and what obligations do they have? And parenting time, people say, oh, I want 50-50 custody. Well, you're going to have joint custody and joint guardianship. And then it's the parenting time that we talk about as being divided. When the new Family Law Act came in 2013, one of the most important things it did is it defined relocation. And relocation is a tricky issue because if you have 3 children and you're living on the North Shore and you separate and you all of a sudden can't afford to live on the North Shore anymore, what do? How do you move to Squamish or Pemberton or out in the valley if your spouse and his job and his parents and 5 siblings all live in the North Shore and you're not getting enough support to be able to stay living there? So relocation is an issue that that does come up, and it's something that is an important issue. And if you are considering relocating, it's certainly something that you need to consider talking to your family law lawyer about. Calculation and payment of child support is less tricky than spousal support. Most people know that child support flows from an examination of how much money do I earn, how many children do I have, and where do they live. But as I mentioned before, calculation of income or determination of income isn't always straightforward. So that is a little bit of a tricky issue, but that's where it becomes relevant because we need to look at who's earning what money from all sources, okay? And then how child support is calculated once the income has been determined. And that includes, so child support is a separate amount. Child support includes the basic food, clothing, shelter, okay? And then the expenses that are on top of that are called special and extraordinary expenses. And those are the kids' activities. So that might be high-level swimming or high-level athletics of some kind. It might be orthodontics or tutoring. So those expenses need to be agreed on, and it needs to be agreed how those expenses are going to be shared. It is not a presumptive sharing, presumptive equal sharing. Those expenses are shared in proportion to income. Determination of income, my slide here, this is never, ever simple. It just isn't. Because determination of income, when we start and people come into my office and they say, oh, here's his tax return, that's just the starting point. When you look at a tax return, you look at employment income, you look at self-employment income, net rental income. Well, rental income, everybody nets it down to zero. There are rules that we follow for filing our tax returns. There are things that are allowed for filing with Canada Revenue Agency that are not allowed when it comes to reducing your income for child support purposes. So if a person is self-employed, we need to look at the expenses that they are deducting through their business. You look at cell phones. Is it all business? Is it all personal? I'm sure all of this is sounding very familiar to all of you, and you've heard all of these things before. But these are things that when you're talking to your lawyer about spousals or about child and spousal support, these are some things that you're going to be looking at. And when we talk about what income is included, all kinds of income from companies, family trust income, pension income, RSP income, interest income, capital gains income, income from all sources, including if there's rental income, you look at the gross revenue. And if a person is self-employed and they've got a number of corporations, you're going to be looking at the pre-tax corporate income as a starting point. So it isn't easy. As I said, it's never, ever, ever simple, but you do want to be talking to someone who knows what they're doing. When I mentioned in collaborative divorce, we refer our clients to specialists. we almost always engage a financial neutral, so that if there's one party who needs help with financial planning or understanding the budgeting or needs some financial literacy, it's so important for that person to receive that information, because what you don't want is a person sitting in a collaborative law case and feeling like the two lawyers and the spouse who owns the company are the only people who know what's being talked about. It's just an uncomfortable feeling. So financial literacy is talked about in the very beginning. And do you really have to review it every single year? You do for child support, absolutely you do. But our goal is to set out the mechanism, the separation agreement. The goal of the separation agreement is to clearly identify the mechanism for review, so that you feel like you know, okay, this is what I'm doing. This is what it says right here. This is how we review child support. This is the clause. This is when we do it. This is how we do it. So that's the goal for us when we're drafting your separation agreement. Division of assets and debts. It probably won't surprise you to hear that family property is divided 50-50. But the issue is, what is family property? So family property in BC is everything that is owned by either spouse. Everything. Car, RSP, corporation, cabin. If it's owned by the spouse on their own, jointly by the spouses, or even with the spouse and another person, it is family property. And it's divided 50-50, and that also applies to debts. So even if there's a credit card you don't know about, or if there's a line of credit you didn't sign up for, the starting point is that that is family debt, and it's going to be divided equally. So from that presumption, we then look at, okay, are there properties that are excluded? Were they inherited prior to the relationship? Were they inherited during the relationship? Were they owned prior to the relationship? So we take a look at those issues and see if there's anything that can be carved off to be which would be the property of that spouse. So if you inherited a $100,000 RSP during your marriage, you can claim an exclusion in certain circumstances, and that property is not divided. So excluded property is not divided. Would add a gigantic but or except after that. But it's not simple. When you go to your lawyer and you're getting your documents organized, you certainly want to be organized and have those documents with you to prove your exclusion. And yes, does marriage make a difference? In BC, when the Family Law Act changed, the rights of the non-married spouses became equivalent to the rights of the married spouses. So non-married spouses now have the same ability to apply for division of assets and debts as married spouses. What if you have a prenuptial agreement? Well, prenuptial agreement or a marriage agreement is absolutely essential. I tell everybody you should have one. Most people don't have them. And if you do have one, it might help guide you at the time of separation. For example, you got married 10 years ago and your prenuptial agreement says we're going to divide this, but not this. Hopefully your prenuptial agreement was done by a lawyer. Hopefully it's properly witnessed, properly signed. And if so, it's likely a binding agreement. So a prenuptial agreement or a marriage agreement does make a difference, and it can determine how those assets are divided and or if spousal support is paid or not. So when are assets divided and how the heck does all that work? I sort of made the question a little bit informal because it's a tricky question. The assets are not all divided at the same time. When you sell a house, you're standing on the sidewalk, you've got your check. Well, that's when that asset is divided, when it sells. A pension asset is divided as of date of separation. Other assets, you might want to postpone the division of them. For example, people who were separating in April didn't want to be dividing their RSP portfolio, or maybe they did, depending on which side of the claim they were on. So the answer is when assets are valued, depends on when you want them valued. If you are in a non-litigation case, you can make that decision, and you want to make it in the most tax efficient manner for your family. Spousal support is another issue that is very common in family law cases. It is not as simple as child support. Spousal support is a payment by one spouse to the other, by the higher earning spouse to the lower earning spouse. And there's a two-step test. It is paid when entitlement is proven. So if a spouse is entitled to receive spousal support and there are the means and there are the needs, then spousal support is paid by the higher income earner to the lower income earner. And the answer to who gets it is the person with the lower income. It's not applicable in every case, and it is not as simple as child support because it depends on how long you were married, what your roles were in the relationship, how much you earn, your education, your health, your age, the conversations you had about payment of spousal support. All of those factors go into determining whether spousal support is applicable in your case. The longer the marriage, the more likely spousal support will be payable, which is logical. You calculate spousal support by considering all of the factors that I just referenced. And lawyers, all family law lawyers, we all have the same software and we all work with the same program to give a range of options for spousal support. Before the spousal support guidelines came into being, the judges and the courts were making random decisions about amounts of spousal support. So these guidelines do help us provide us with a range of the amount payable, and then where you fall within that range usually depends on the factors that I listed before: age, health, education, length of marriage, age of your children, and so on and so forth. And how long does spousal support last also depends on the length of your marriage, your income, your spouse's income, and your age at separation. And what if your spouse dies? That's when you want to make sure that your separation agreement was properly drafted, and you want to make sure that the spousal support order is binding on your spouse's estate. Because if your spouse dies 1 year into your spousal support agreement, and it's not binding on his estate and he or she has no life insurance, then your spousal support is over and you have no claim. What if I don't ask for spousal support, then I change my mind? Well, this would be one of the reasons that you should be talking to a lawyer at separation, because oftentimes people will say to me, no, I just don't want it. He's never going to pay it and I don't want it. Spousal support is a way to equally divide the economic consequences of a marriage breakdown. So if you have a spouse who has a long resume and they've worked for years and they've had many, many promotions, every line on their resume, every dollar that they've earned has been earned as a result of the spouses working together. So there is an entitlement. It's not always easy to think about, well, I don't really want to receive the money from my spouse. You have an entitlement. It is the fair way to divide the economic consequences of the marriage breakdown. It's taxable income to the recipient, and it's a tax deduction for the payor. And it is a hard conversation to have, but if you don't ask for it and you sign a separation agreement, then you will not be able to turn back the clock. So the next slide says, what do I do? The first thing I would say to you is talk to a family law lawyer. Most family law lawyers I know offer free phone calls. Most people who go into the practice of family law do it because they want to help people. They know that there's a better way to do separation. It is a challenging, it's probably, I would say, the most difficult area of law to practice because of the emotions involved. And when people walk through my door, they're generally going through one of the worst things they've ever gone through. It is very important to get good legal advice in the beginning. Get some information, find out, what should I be doing? And also, as importantly, right now, especially if you're just thinking about separation, which the poll tells us most of you are, you need to know what not to do right now as well, okay? And a family law lawyer will help you with those questions. Do some research. Every law firm website that I know has a resources page. Go to that resources page. Look at the Legal Services Society. They've got a great website which answers all the questions about child support, spousal support. Talking to your neighbor about what he or she got in their separation is the least helpful thing that you can do, because nobody's case is the same. People who love you and care about you are wonderful for emotional support, but people who tell you that you've got to go after everything and get everything you can possibly get are not helpful. A family law lawyer is going to give you a reasonable assessment of your case, and they're going to explain to you the best process to engage in, and they'll give you step-by-step instructions, and that's where you should start. The emotional support for yourself and your family is also key. If you do not already have a counselor or a therapist that you're working with, that's what I tell almost all of my clients to do immediately, because that's where you want to be going for your emotional support, not in my office. It's not that I'm not a good person to talk to, I am, but I'm better at giving legal advice than I am about giving personal advice. So get some emotional support for yourself and your family. If there are children, absolutely your children should be in some counseling. If you're separating and you haven't told the children, having a parenting coach give you a script for how to tell your children is a remarkable thing. I've watched couples do this. I had one high conflict case, so they were both police officers, and they got a script on how to tell their kids. And when they came back into the mediation session with me after they'd told their kids, it was about a month later, they were both sobbing, including this, big burly police officer, because of how well the script had gone, and what a surprise it was to them how well their children took it. So getting organized means get your tax returns, get your property assessment, get your mortgage statement, your bank accounts, your credit card statements. All of the things that your family law lawyer is going to ask you about are the things that you need to resolve. So if there's an RSP, get your RSP statement. If you have a bank account, print off a bank account statement. That's how you get organized. So, now, some people simply don't have access to those things, and that happens in my office all the time too. Just do what you can without putting yourself at risk. Okay. And the final thing that I'm going to say to you is you're not alone. You're not alone. There are many, many people in your situation, and family law lawyers and family therapists and the financial neutrals that we use. Everybody cares about the people that they work with. So reach out to somebody, and that person can put you in touch with a team of people to support you when you're going through what you're going through. So I'm going to turn things over now to my colleague Kamal, who's going to let you know about an upcoming webinar, and then we're going to have time for questions and answers. So just hang in there, and if you type your questions and answers into the Q&A bar, I'll be able to see them, and I'll be able to answer them for you in just a minute. Over to you, Kamal.
Perfect. Thank you so much, Karen. Before we get to the question and answer, and it gives you a chance to type in your questions, I just wanted to let you know about an upcoming webinar. The speaker, Neeraj Jain, is a portfolio manager. So it's a very different topic. It's a market update, and he's going to talk about investment strategies and what you should look for in the current market environment. And similar to this webinar, check out sophiawealthacademy.com under the events tab, and you'll be able to register there. So that's happening in just about 3 weeks. And now let's look at your questions. So feel free to type in the Q&A box. And Karen, we've got one that already from Lisa, who asks, what happens if the kids don't go to counseling? Oh, Karen, we can't hear you. Can you unmute, please?
I'm sorry. Sorry about that.
We got you.
Sorry. We all have our strengths, Kamal. Mine is not technology.
No
so
worries.
Yeah, not all kids either want to go to counseling, and oftentimes you can't get both spouses to agree that the kids can go to counseling. So although it's ideal, it doesn't happen in every single case. I'm just referencing it as as an ideal situation where you would take your children and they would have someone to talk to. So it's not, it's not mandatory, but it's just something that I don't think I've ever met anybody who couldn't use a couple of hours of counseling. Let's put it that way.
Perfect. Thank you. And Lisa asked a question. She said she's worked with a collaborative lawyer, and she found the process, she found it difficult because her partner, she realized there's a power imbalance, and her partner comes across as very charismatic. And so she found that difficult being even in the same room with her. What do you suggest?
Well, I hear that all the time. All the time people will say to me, oh, he or she is going to smooth talk the room. I'm never going to get a word in edgewise. You guys are going to believe everything he says. And so I let my clients know that I see that all the time. And look, as a team, we're there. We are 4 people there to resolve a problem. It doesn't matter to me who's the smooth talker, who's the person with the most information. It really doesn't matter. But I do absolutely recognize that it's sometimes, it's difficult. It's cringeworthy to even sit in a room and watch your spouse behave that way. The best I can say to Lisa is that your lawyer should make you feel supported. Your lawyer should make sure that you're comfortable and that you know, going into the room, everything is important. Where you're sitting, how much you're talking. Do you feel that your lawyer is someone's encouraging you to speak, so that you're not feeling that your spouse is the only one doing all the talking? It's a conversation that you should be having so that you feel comfortable, because it's very, very common.
Perfect. We've got another question from Lana coming in, and she asks, when is it best to use collaborative divorce versus mediation? I understand that mediation is one person for both spouses. When is that a better choice?
That's a great question. You know, sometimes I say to people, look, mediation is faster because you're only trying to figure out one person's schedule. And sometimes it can be cheaper. Mediation is incredibly effective if you have two people who are on the same page and if there isn't a massive power imbalance. If you've got an emotionally abusive situation where there's a big power imbalance, and one mediator is going to have difficulty with that. But if you've got two people who are equally informed, or at least a situation where the other spouse is willing to be informed and the conversations are open, then mediation may be appropriate. What I would say is contact a lawyer, a family law lawyer who's also a mediator, someone like me, and talk through your particular case. So it depends on the facts of the case, but you know, if you're looking for a quick and effective resolution, choose the right process, and then that will be the fastest and easiest resolution. It's when you choose the wrong process that you end up wasting money, because you're trying to do something, you're trying to engage in a process that doesn't work for the two of you.
Perfect, thank you. Jennifer asks that all spousal support is taxable, but isn't it true that if one receives a lump sum of spousal, yes, that it's not taxed?
That's exactly right. Monthly spousal support. So if I misstated that, when you receive monthly spousal support, it's also called periodic spousal support. That is reported on your tax return, and that is taxable income, but lump sum spousal support is not. And it's not calculated, you know, the certain amount of money times the number of months. It is reduced to account for taxes. So it is less when you do the math, but the taxes are counted in. You just don't pay the tax when you receive the lump sum.
Perfect. Joan asks, how is the identification and valuation of assets done, and who does this?
Great question. It depends on the asset. So if there's real estate, then we want to engage real estate appraisers. I've had antique car appraisers come in and appraise antique cars. I've had jewelry appraisers. If we have a portfolio that's complicated, then we'll bring in a financial neutral to give us advice about that. If there's a business, we will engage a certified business valuator. So the answer, Joan, is that it depends on the asset, and we will engage those professionals for you, or you can engage those professionals yourselves, as long as it's done with the two of you together. What you don't want is a situation where you hire one appraiser and he or she hires the other, and then you've got the war of the appraisers. You want to do it together.
Perfect. And Karen, I get asked this question a lot, which is, how do I know that my spouse isn't going to hide assets?
Oh, that is such a great question. Well, it won't surprise you to hear that almost every single person is sitting in my office says, I just know that there's money hidden, right? And so I tell people, you know, if it's in the British Virgin Islands in a black hole, you're never going to find it. But if it's in Canada, in a bank account or in an RSP, there, you know, these days with technology and with paper and electronic bank accounts, it's not difficult. You know, we look at bank statements and we see transfers. Oh, there's another account. When a party signs on to a collaborative process or mediation process, they are signing on, they are agreeing to disclose all assets. Through the process, it is almost with 100% certainty, I say this to people, we will find all of the assets, because your spouse will be told by his or her lawyer that the separation agreement will be null and void if they don't disclose all assets. We also have most spouses sign a financial statement, which is a sworn statement of property and debt. Again, if you have the spouse who's going to be determined to hide things in the British Virgin Islands in a black hole, you're never going to find it anyway. But most people sort of have that secret $10,000 bank account stashed away. That's the extent of the hidden money, and those things are easy to find.
Perfect. And Daniela asks, is the JCC mandatory even if you want to do a collaborative divorce or mediation?
Nope, you do not have to. If you've started a court process, you can, even if you've started a court case, you can opt out of all of that, including the judicial case conference, to choose a process whereby you're meeting with collaborative lawyers and or a mediator. So no, it's not mandatory if you choose another option.
And Karen, what can you do if your spouse doesn't want to go to collaborative law? Also
a great question. So people come into my office and they say, you know, I want to separate, and I've tried 5 times. I've told him or her I want to separate, and I can't get any traction. He or she won't listen. He or she won't move to the other bedroom. This isn't happening. So I have what I call a collaborative invitation letter that I send. I send a letter to the spouse saying, we've been retained by your spouse and he or she would like to resolve matters in an amicable fashion. We ask that you take this letter to your lawyer. Here are a list of lawyers who practice collaboratively in your area. And I reiterate my client's wish that things be settled in a manner that is collaborative, amicable, and allows all parties to move through the process in creating the least harm. So I call that my invitation letter because it invites a person into a process. It's non-confrontational, it's not threatening, but it says to the spouse, I'm serious. I've got a lawyer and you need to get a lawyer. So that's the first step. The second step would be a more shortened version of that letter, a bit sharper. And if we still can't get your spouse's attention, then sometimes we do have to start a court action. And the court action, the importance of filing the court action is then your spouse doesn't have a choice. They've now been served with a document that tells them that they've got 30 days to file a reply. Once you file that court document, I would say 9 times out of 10 in the cases where I've done that, the spouse then says, okay, I'll let's mediate. Most people don't want to litigate. So if you can't get them to come to the table, you try the collaborative invitation letter. And if that doesn't work, then you can start litigation.
Perfect. And we'll take one more question. And this one is asking, can you go from collaborative to litigation if it doesn't work? And I guess the other question would, of the flip side of that, could you go from litigation to collaborative?
Well, you definitely can go from litigation. You can go either way. But with when you're in collaborative, if it's not working, there are notice provisions that you need to give. You can't just change your mind on a Friday and start a court action on a Monday. There are notice provisions that you have to follow, and then you have to engage new lawyers, because if you've engaged your lawyer in a collaborative process, then that same lawyer can't go with you into a litigation process. If you are in litigation and you want to engage a collaborative lawyer or a mediator, absolutely you can. People come into my office for that all the time. They get litigation fatigue and they want to resolve matters by way of mediation. Yes, you can.
Perfect. Well, thank you so much, Karen, for all of the information. And this is always a period in a person's life where there is a lot of emotion circling around. And the way you went through the presentation with the rational facts and the steps, step by step, and getting a good lawyer, getting legal advice, all of those things are very, very important. And I'm sure our attendees appreciated that. So thank you again for tonight. And
thank you, Kamal.
You're very welcome. And please check out SophiaWealthAcademy.com for our upcoming events. Thank you, everybody.
Thanks, Kamal. Good night, everybody.